Okay.
I've got a lot of slides. We can start it and people can come on at any point and that they want, or we can wait a few minutes if you want for people to join. So leave it up to you guys.
Sure, so I think people are gonna start filtering in. Andy, if you wanna go ahead and just set up your screen, that'd be great.
The slide share, screen share, that, let's see here.
You think
Is
it's
that
ready?
got it? I can't see it from how you're looking at it.
You might have to press either, what was the button? Was it present online or from the beginning? We can see it like it's in the program.
Okay. That better?
No, that's too big. That's a better size. I think that's good.
Okay.
Okay. We'll take a couple minutes or, let's see here.
Is the sound okay?
I think it sounds good.
Yeah.
Great, thank you. By the way, great job on the last webinar. It was a lot of fun. Nice.
Thanks, Andy. So we do have 28 people in attendance. Jordan, if you want to go ahead and get started, I will defer to you and you can introduce Andy. And Andy, thanks so much for being here and everybody for being here.
Sure, thanks, Natalie. My name's Jordan Winquist. I'm an attorney, representative of the National Lawyers Guild Environmental Human Rights Committee. I'm based here in Philadelphia in Lenape-Hoking territory. And Natalie Segovia and I coordinated this series of webinars. This is the second of 4, and this includes Professor Andrew Reid. Professor Andrew Reid has been with the National Lawyers Guild since 1975. He has worked with Indigenous people's rights and international law and environmental issues for the bulk of his career. I'll read a little bit from his bio. So he's been part of over 50 published opinions on the rights of Indigenous peoples, opposition to weapons of mass destruction, protection of the ecological integrity of local communities and the earth, and significant civil rights issues. He started with representing Seminole elders in Oklahoma and the Sokaogon Chippewa in Wisconsin on treaty claims, and on the restoration of the government of the Menominee Nation following restoration. Then he proceeded with the Black Hills, where he worked with the Black Hills Alliance to successfully protect the sacred Paha Sapa from destructive uranium mining. He currently serves as special counsel and member of the WPLC Water Protectors Legal Collective. Andy is also, he's an adjunct professor at the University of Denver Sturm Law, and he's counsel for the Vednanda Center, the Vednanda Center for International and Comparative Law. And without anything else, I'll pass it along to Andy to get started. Thanks, everyone.
Great, thank you, Jordan. And if I need to do anything, let me know, because I'm depending on you. I don't know how it looks for you, but I think it's okay. I prepared a PowerPoint. It's a crutch for me, but it basically focuses my presentation. The PowerPoint kind of combines 2 courses that I teach, one on the international and human rights law of indigenous peoples, and the other one on environmental ethics and justice, in which I cover earth jurisprudence or earth law, as well as eco-socialism and ecofeminism. What I'd like to, so I'm giving you within 1 hour essentially what would normally be a 4-month presentation in 2 courses. You're getting six credit hours at the law school. But I'll go through it quick. And it's kind of something I've developed myself. I don't know anyone else that goes through this presentation, so please take what I don't pretend to be someone who knows everything. I think I know a lot. I've had a lot of experience in this area. I've taught for over 10 years. And, but I have some ideas and approaches that are fairly unique within both environmental law and within the law of indigenous peoples and the struggles of indigenous peoples for liberation. One thing that's interesting from both my backgrounds, there's a few of us who have experience in both environmental law and as well as Native American law, formerly called federal Indian law, as well as international human rights law. But there's only a few of us. David Getchus was one, but David died a few years ago. But there are a few. And what I've seen over the last few years, and it's where I first met Jordan, for example, was this conversion between economics and the environment and society that has opened the door for reconsideration of an indigenous approach to law, in the way that law is simply the rules or ethics that we use in making decisions, making hopefully the proper decisions in regards to our life experience. And so what's happened recently, and I met Jordan up in, or we went to Rio de Janeiro for the Earth Summit a few years ago. And it was kind of a lot of this is starting to come together so that you have environmental community now starting to look for different directions and different ideas. And then you also have Native American, the native communities, and I don't mean to use Native Americans because they're not Americans, but the Native communities becoming more empowered and more aware and more capable of defending themselves from colonial rule and work towards liberation. So, and those things are coming together at a unique time of global climate change and environmental crisis, as well as the exhaustion of natural resources. So it's a building storm here that I think poses some real paradigm changes for our future, particularly in regards to how we approach nature. And that's what this presentation is about. I'll go through some of it pretty fast, and I apologize to those that may already know this stuff. I think it's important to go back through it. I had to go back through and teach myself some of it because obviously it was never taught in law school. And so that's the beginning of it. I'm going to take, for those of you that are lawyers who've gone to law school, then you always know I have a property one course, and it starts with certain concepts that came out of the theories of John Locke, who's considered the father of Western property law. And he wrote in his second treatise, he created a logic for the creation of property and private property. And so this is a quote from that that I'm going to cover. The strange thing about John Locke, when I went back and the second treatise is part of the reading material. By the way, there's a big batch of reading materials that you can get to support this, that you'll see on the notice for this webinar. But one of those is the second treatise. If you go to the part on property, he talks about how how this concept of property came about, and it comes directly out of the Bible. And this is something that when I first started reading about this and thinking about it, it started making a lot of sense. And we think of property law as being fairly neutral, but actually what we have is a Christian ethic that's been incorporated into our concepts of property and property law. And that Christian ethic, according to John Locke, and it's in black and white, says that property evolved, property developed directly out of the relationship between man and God that's described in Genesis in the Bible. And he says that God gave mankind in common the earth, and And then he went on to talk about how he's using that to show how property evolved and came about. Now, this background is important because what it'll do is it helps us create an understanding of what the limitations are in terms of our current theories of law regarding property. And the law of property is what governs also our law regarding our relationship with nature, which we call environmental law. And so the origin of property, and this is all from John Locke, he talks about every man having a property of his own. Now, part of this comes about because in Genesis, the Bible talks about God creating man in the image of God. And so man is a sacred being. And therefore every man has a sacredness of property in his own right. And a lot of this is where the individual concepts of individual liberties, individual rights come from. Some people want individual sovereignty. And then because he has this sacredness about him, in the image of God, and nature does not have that. Nature was not created in the image of God. Then nature was created to provide for man, and such that when man mixes his labor and does something with the earth, with something that's part of the earth, picks an apple from a tree, tills a ground and plants some corn, even goes to a stream and takes out a bucket of water. Once man mixes his labor with that inanimate, quote, in other words, something that doesn't have any intrinsic value, that inanimate part of nature or even animate part of nature in terms of animals and plants, once he mixes his labor with that, it creates something of value. So man is sacred, and once he engages his sacredness with the earth and takes it of his own, then it becomes property and becomes something of value. So the earth, under Locke's theory, the earth has absolutely no value until man mixes his labor with that part of nature, and that's what creates property and makes something of value. And so it's called Locke's theory of labor, right? And it also creates the right of private property, because what he talks about is once it leaves nature, because a human being has taken that, then that taking becomes the property of the person that took it. So it becomes private property. And one thing that's important here is that he knows that it doesn't depend on the express consent of all commoners. So it can be taken without getting anyone else's consent. By the way, this last little sentence here is one thing that distinguishes a Locke labor theory of property from communism, because communism, of course, the taking of a part of the commons or part of the property does depend on the consent of all the commoners. So that's one of the distinctions between a biblical view and a Marxist view. But anyway, Locke goes on to talk about man owning the earth itself, and that when he tills and improves, cultivates, it becomes his property by his labor. And he also talks about what God did in Genesis, and he says that God commanded him to subdue the earth. Right. So, in creating this relationship between man and the earth, it's a relationship of domination, and this concept of domination follows throughout man's interaction with basically everything around him. And we'll see later how God actually commanded man to rule over women, and commanded, and this domination, this is a domination of the earth. Man ends up dominating, let's say, other beings, such as people from Africa, and children, dominates animals, and dominates the earth. And there is by commanding man to dominate the earth, then God is ordering man to do something, and humans then have to fulfill the will of God. So then by dominating the earth, man is engaging in a sacred act. And it's really hard for me to get around this, but I think it's important for us to understand that, particularly if you're looking at this from a point of view for those that actually end up following this line of thought in developing Western property law. So the creation of property then becomes a sacred act. You're fulfilling the will of God, you're combining your sacredness with the earth, and you're creating something of value. which God wanted you to do. So it becomes a sacred activity. And you'll find this for those that push the human right to property, for example. When they talk about it, they'll talk about it as a natural right to property. When they're referring to it as a natural right, then it's a right that comes with their existence. It predates positive law, predates humans, and it becomes something that it's a natural right. It's something they're obligated to do by nature. And so in obeying God, then humans are engaging in the exploitation and subduing of the earth. And he knows that this was a law, that God created this law. So this is the original law, and it was a law for appropriating from the commons by man through his labor, by cultivating the earth, by joining together. And by joining together, then Locke says that it gives title. Gives title means ownership. It gives title to the individual that does that. And so it creates a title of property. So from the Old Testament, this is what Locke was going on. This is from Genesis. It talks about dominion over the earth and so forth, everything that moves on the earth, every plant yielding seed and so forth, every tree. And this comes from the part of Genesis where Adam and Eve were ejected from the Garden of Eden because they disobeyed God. And when God, and I apologize to anyone that's devout Christian or whatever, this is not meant to offend you. I'm just telling you my thoughts and the way that Locke actually was thinking at the time that he created Western property law. But in Genesis, the Bible, they kicked Adam and Eve out because they shared on the tree of knowledge, and he cursed both of them as well as the snake. But the curse on women, of course, is that they have pain in childbearing, and that they also cursed women by making her desire for a husband and ordered that the husband shall rule over the woman. And then he also cursed Adam and forced Adam to toil. So before in the Garden of Eden, Adam didn't have to work. Nobody had to work to be fed. And it's my understanding they didn't age. After they kicked out of the Garden of Eden, then they would have to toil the earth. They would have to harvest, or they would starve. And so he ordered them, by the sweat of your face you shall eat bread till you return to the ground, earth to earth. And God sent him out from the Garden of Eden to work the ground from which he was taken. All right, so that's the curse. And because this is a sacred order from God, it's become incorporated within Western property law, and it's made the right to property as a cornerstone of all other rights. William Blackstone, who's another father of English law, noted that so great is the law of private property that it cannot be taken, even for the general good of the whole community. In other words, the right of private property trumps the common good. In the Law of Nations, you'll find it was also adopted, incorporated within Vattel. Vattel is one of the father of international law, and so he incorporated this concept within his book called treatise called The Law of Nations on cultivation of the land as a natural obligation. And there he's talking about Genesis and the order of God. And he talks about it as being an obligation imposed by nature on mankind. So this is a sacred obligation. And if you don't obey God and you don't fulfill that obligation, then you're disobeying God and you're being disobedient. And by the way, that was one of the grounds that Chief Justice John Marshall used in the Cherokee Nation trilogy, specifically McIntosh, to deprive Native people of the right to their land. They said that by not tilling the land, by not enclosing it with fence, and by not doing exploiting the land as God ordered, that they had no right to it. And that was one of the grounds for ruling that Native people did not have title to their land. This comes directly out of Western property law. John Locke and Vattel. Locke and Vattel were both writing at about the time of the creation of the United States. And were both read and followed by Marshall and the others who created that. Then Locke talked about, this is still on Vattel. He talks about the natural rights of men. Note that he says that the natural rights of men, this is to the earth, to exploit the earth, is repugnant to the views of nature. So this creates a situation where you have men on the one hand, human beings, and then you have nature on the other, and that the acts of human beings is repugnant to nature. And this is international law. This was the original international law of nations. It's considered a natural, coming out of natural law. And by the way, Chief Justice Gorsuch, who wrote the opinion today on jurisdiction of the Creeks in Oklahoma, he's a follower of this natural law concept and natural rights and so forth. He studied it in Oxford and got a PhD, or got an LLD in it. But anyway, that God destined the whole earth to supply the wants of mankind. So you see as that not only was this incorporated in English law and the law of the United States, but it was also incorporated within the concepts of property law at an international level. So you end up with this dichotomy between paganism and Christianity here that I won't go through, but it's really, it's different worldviews. I think that's the most important part. And so you have one worldview, the Christian worldview, that's going to take precedence. Another thing that Locke talked about was the creation of money and why it came about. And one thing he noted that human beings were required to exploit the earth and take all that they could. The accumulation of property is a good thing because when you're using the earth and you're exploiting the earth and you're fulfilling the will of God, problem is once you start accumulating property, it starts spoiling. And so he talks about the money coming about in order to use money in the place of property. So you can actually accumulate more property by accumulating money. And that created the situation we have today. Marx talked about money in his writings, talked about money as being the bond of all bonds. It's the bond of society. He talked about by dissolving money, you could dissolve the bonds. And that money is the universal agent of separation from human beings to nature. And if anyone who's interested in there's a recent concept called the metabolic rift that has been developing within the eco-socialist movement. Ian Angus and some others write quite a bit about this, where they're reinterpreting Marx in light of human beings' interaction with nature within a Marxist analogy. But anyway, where we end up in Western property law is that there's a right to private property that's primary. And Locke also talks about this private property right as creating the necessity for governments. So when he goes on in the second treatise to talk about once private property was created and once people started accumulating property by taking it, then they needed to protect their property because that was a primary right and it's fulfilling the will of God. And therefore, human beings gathered together in communities and created governments and so forth. And so the primary obligation of government, and think about this, the primary obligation of government is to preserve private property, protect the right of private property. That's the primary obligation. So once you start thinking about these things, for me anyway, once I started coming to terms with this, it started making sense to a lot of things. I've been practicing environmental law and natural resources law for over 40 years. And for about 20 of those years, I couldn't really understand why it wasn't more fair. And why when you had, for example, the Environmental Protection Agency, why it wasn't engaged in actually protecting anything. And I realized then that that what we have going here is that all of our laws are anthropocentric. In other words, they've separated humans from nature, coming from Genesis, and it was incorporated within Locke and other English property law thinkers. And then we ended up with a very anthropocentric view of the ethic of the law that we create that regulates our relationship between nature and human beings. And you'll see this in everything. So even in the laws that we have that we think are meant to protect nature, take the Wilderness Act, for example. If you go back and you read the Wilderness Act, the Clean Water Act, the Endangered Species Act, the Clean Air Act, the National Environmental Policy Act, which creates the Environmental Protection Agency. None of those acts talk about the intrinsic value of anything, of nature and the earth. What they talk about is the preservation of parts of the common of nature for the use of humans. So all of this is anthropocentric, including all of our environmental laws. And because of that, you cannot have a law that actually protects nature in its own right, that protects a tree or a grandfather tree or a mountain or a stream or a species in its own right. It's only protected in terms of its value to human beings. So a lot of it talks about the future value that something in that area might have, or that the importance of the wilderness to human enjoyment and the enjoyment of life and so forth, but always for humans. And so you end up with something with environmental regulation instead of environmental protection. We don't have environmental protection in this country. We have environmental regulation. And when things are stopped like the Dakota Access Pipeline, for example, was recently halted because of it was halted under a regulatory law. They had not complied with the regulations that require that the issuing of a permit be reasonable, that it be that they follow reason, which is the whole purpose of the an environmental impact statement is that it's a document of discussion so that will document the reasonableness of the decision of the agency. And so those are regulatory laws. They don't protect anything. There's nothing that says that you can't have something that's beneficial to human beings but protect it completely, put it off limits to human beings. It's more of a situation where they have what are called a set of alternatives, and for example in an impact statement, the first one is usually no alternative, and that one's almost always rejected. And but the only reason why even a no alternative would be chosen and not developed to be protected would be only if it was for the benefit of human beings, not because it would be the benefit of the environment that's being impacted. Oh, it's also why we have the rule against perpetuities, because the rule of perpetuities takes property off the market. And so it's important that human beings be able to use the land under this concept of John Locke and others. And so we actually have a law that says that you cannot tie up land forever that way. So we have other laws that privatize the earth, and this all comes out of this concept of earth being having to be available to fulfill God's will and it being exploited. One of the original ones is the 1872 Mining Act, which is a disaster for public properties. Privatization of forests, which we even see within environmental laws. RED is supposed to be an environmental program to preserve forests, but it's actually become making forests a commodity. See the privatization of water being sponsored by the World Bank, forced on nations, and forced on Bolivia, which led to the water war and the overthrow of the administration there, and the rise of Evo Morales as president. You'll see it here in the patenting of seeds in in Monsanto, for example, where they held that this individual property right, going back to Blackstone, this individual property right trumped the right of the surrounding people not to have their crops contaminated by patented seed. That the patent trumped the rights of the neighbors. And in Pakistan and India, for example, the farmers can't afford the seed, nor the chemicals, nor the water that's required to grow them, and they've been going, they're pushing them into poverty and bankruptcy, and they've been committing suicide. I was attorney in mandatory country of origin litigation before the World Trade Organization for a coalition of farm groups and ranch groups and environmentalists over the country of origin labeling. It's called the COOL Act. And what that does is it provides consumers not with the information regarding where their food products come from, and the WTO ruled that violated the commercial rights of the producers, maybe, which I think in this case it was Mexico and Argentina, in the production of beef, for example, and therefore it was thrown out. But that's another show where the individual right of property and the profit motive trumps the rights of the common. There's Margaret Thatcher. And in environmental law, we have something called the cost-benefit analysis. It's used in a lot of other places, but basically it's how these decisions are made. You'll see it in almost every environmental impact statement. But they look at, well, what are the risks, which are the costs of a project, and then what are the benefits? What are you going to get out of it? So benefit might be, well, it's going to create jobs. And you'll see this in the recent argument before the court, both in DAPL and in KXL, where they're arguing that if you shut down the pipeline, you're going to destroy thousands of jobs, all right? That's a benefit, and it's also a cost that way as well. Cost would be the contamination from excursion from pipelines. Now, benefit, of course, would be the production of oil for use in cars and production of energy and so forth. And almost always for these kinds of projects, the benefit outweigh the costs, or they do some way to mitigate the cost. But involved in that cost, it's interesting in terms of how this reflects the Western thinking in terms of property, is that these cost benefit analysis, they even monetize human life. So in this, on the right, you'll see the nuclear power trial that involved 3 Mile Island and the sacrificing and the environmental impact statement of the lives. I think it was 5 people over the lifespan of the nuclear power plant. This other case on the right is the Indian Point nuclear power plant, in which I was counsel on environmental justice litigation. And again, that talked about whether or not the lives of people of color were worth less than the rights of both poor and people of color were worth less of white wealthy people in the area who might be exposed to radiation if there were an accident at the nuclear power plant. It was an interesting discussion there, and in that one we actually won that one where the agency said that there was an environmental justice violation, and that went up on appeal later. I talk about it more later. But the interesting thing about it is they even value life. Here's a study that talks about the value of a life. And so, for example, if the value of a life is $200,000, but the benefit of the oil and so forth is $10 million, then obviously we'll sacrifice 10 lives so that you can get that oil in. And you can value illness and so forth. You can even value children. And there's an interesting study where they had to figure out, well, how much is this child worth, right? And so what they did is they did a study where they looked at how much time mothers spent making sure that the children were belted into the car properly. And then they looked at the difference in time between belting the child in properly and just belting the child in quickly. And they noticed that it took an extra 15 minutes or so, or 5 minutes or 10 minutes to put the child in the chair properly. And then they extrapolated that from over the child's lifetime, being in the child's seat. And then they figured, well, that's the worth of the child. So they, found out that the child is only worth like $40,000 or something like that. That's an actual determination they went through. We valued, we've made human beings private property. We not only have it in Dred Scott, which is an amazing decision. And for those of you who haven't read it, I encourage you to do that. We've been selling people ever since. There were children sold during the 30s. There's children sold even today with human trafficking. One thing in the bottom left corner, there's a reference to the law of Burgos, which was actually the first law in the United States. It was promulgated at the time of Columbus' first landing in the Caribbean. And they passed this law, and the law regulated slavery. And it required everyone to have at least 100 slaves and so forth but it's one of the first laws did that.
Andy, we've had one request to increase the volume, if at all possible, on your computer, or just be mindful of it, but keep going.
Okay, that's fine. Maybe I'll get a little closer. I'm not quite sure how I can increase the volume, but I'll try to talk a little louder, maybe a little bit slower. But they even try to value the earth, and there's been a paper out on that, and this is the value of the earth itself. So somebody could potentially purchase the earth. And then we had this combination of Smith on market economy and the hidden hand of supply and demand and surplus and so forth that ended up creating capitalism. And so out of this whole theory, this Christian concept of property, we've developed these values, this way of and these laws. This created a set of laws, property laws, economic laws, as well as environmental laws and laws on natural resource development. They're all based around gross domestic product, where you measure happiness that way. And it also ended up creating a system where the wealthy are at the top of capitalism, and then you have a large volume of masses that both provide the labor that's required for the accumulation of property as well as the concentration of wealth, and which is fulfilling the will of God. Those that become billionaires arguably are fulfilling the will of God. It's resulted in other things in terms of the environment. One of the most craziest things was when the Cayuga River in New York caught on fire, and it led to some of the modern environmentalist movement. So you end up, so what's the result of all this? You end up with global concentration of wealth. I'm not going to go over much of this because you already know this. But one thing that's interesting is the world GDP per capita. So that's the amount of money per person per capita. Look how it has shot up over recently. And what's the result of that? Even though it's been concentrated largely in the super wealthy, everyone's been spending more and getting more money. And so it's resulted in consumption. And overconsumption has become a cancer that's been destroying the ecology and eating up the earth. Here's the world population curve. When I first saw this, I freaked. Normally we don't think of, we think of consumption. When we engage in this discussion, particularly with the eco-socialists, for example, there's a big debate over whether it's an issue of overpopulation or overconsumption. And for me, I think it's both. Obviously, wealthy people and the wealthy nations consume a lot more than others in the rest of the world, but it's become a major problem. And you can follow this just by tracking planetary growth and the consumption of the earth. And so if you look at consumption rate by country, you'll see here it shows on the left, it shows how kind of a bloated figure as to the over-consuming countries and the under-consuming ones. But look at the trends in water withdrawals as population goes up. How about the global food challenge? And there on the materials, there is a video that you can click on the webinar materials. You click on that. I encourage you to do that. It's Earth from Space, and it's a NASA video showing this. This looks pretty, right? But think about the amount of energy that is being consumed here every single moment on the Earth. And I look at this and I freak. And I freak not only because of the amount of energy, but these are population spots. So this shows the growth, the spread of the human race around the Earth. And so we're running an issue of peak oil. And there's been expectations or projections that we've run out of oil for years. But fracking has extended that, but even fracking itself is only expected to go for a few more years, 10 years or so. And so at some point, there will be a collapse of the energy reserves. And our transition over to green energy will make a big difference. They have something called hockey sticks, which shows that all of these, I'm sorry you can't read them because the original is too small. But all of these hockey sticks are like McDonald's hamburgers, or the use of electricity, or this and that. Everything is going up because of the population growth. It's called the Great Acceleration, and you'll see these trends. Real GDP, world population, carbon dioxide. You'll see both Earth systems and socioeconomic systems are just exploding. And what has that resulted in? There's been a blue acceleration of the ocean. So we're approaching a collapse of the ocean resources, of the fisheries, which means that the population of the Earth that depends on that, status of the world's forests, deforestation is a huge problem, and right now, particularly in Brazil. And so we end up with this concept called the tragedy of the commons. And I imagine a lot of you are familiar with this. It was something that was come up with by Garrett Hardin. I believe in 1968, but he talks about the commons as something that everybody owns. You have a sustainable use, which means you have a number of cows that can use that field. And then, but if you put more cows on there, you deplete that field and it can no longer sustain them. And so you end up with a situation where there are limits to growth. In other words, the earth can only sustain so much use, so much growth, and so forth. And of course, it's localized, but it can grow, and so both Dennis Meadows and some others talked about this from the Club of Rome and the Limits to Growth, which these are classics, The Population Bomb, 1968 from Paul Ehrlich, and also talks about that. The thing about the limits to growth, that was another thing like the collapse of the oil industry was also predicted. But what's happened is it was just simply pushed back. And we're finding out now that we are approaching our planetary boundaries limits to growth. And this is a graphic on that. And it won't all collapse at the same time. The oceans may collapse earlier, and water, clean water, some things like that. So we're right now consuming about 150% of the Earth's capacity. We have what's called Earth Overshoot Day, which talks about how long can we go in a year before we've actually used up all that the Earth has to provide for human beings. Last year we used everything up by July 29th. So actually halfway into the year. So in biological terms, we've become parasites that are eating our hosts. This has led to what's called the 6 mass extinctions. There have been 5 mass extinctions in the history of the Earth. And we're now entering the 6th mass extinction, where over half the species of the Earth are predicted to disappear. And this is generally a consensus concept. It's not if it's going to happen, it will happen. We've already lost about 40% of the honeybees. And in one generation, wipe out nearly half the world's marine mammals, birds, reptiles, and fishes. And so we're reaching this perfect storm. They have a term for that. It's called overshoot, where you have a point of no return. And so right now with COVID-19 and some other efforts, the growth of green energy and so forth, we're making some progress on going back on that. But we're already beyond the point of no return. So regardless of what we do at this point, if we completely stopped using oil today, a lot of the global crisis would continue, climate crisis and so forth, and the changes. So it would just mitigate it some. So we talk, in fact, during his term, you'll notice Obama stopped talking about trying to avoid climate change, but trying to mitigate the impacts. That's what this is all about. It's a planetary collapse. So the Earth will make that decision for us. Whether we want to go green or not won't really make the ultimate decision. It will be the Earth, because if we don't go green, the Earth will do it for us. And these are all the levels of our carbon. We had to stay around 350. That's why 350.org got its name. We're now above 400 parts per million on that in the atmosphere for carbon. Average temperature over time, you'll see it's in over 10,000 years, we are higher. This is the temperature increase. This is the change in temperatures. You can imagine what this is going to do, changes in water stress. And so it's coming on within our lifetimes, but so slowly that we don't really notice. So I call it the boiling frog syndrome. And I think most of you know about that. Part of it, there's a term called percepticide, which means you know something's there, but you refuse to acknowledge or look at it. That's what the Republicans have right now. And it's a global economic collapse, environmental collapse. And with environmentalists, atmospheric scientists have called it the oh shit moment. And it's the atmospheric scientists that have looked at this and said, oh my God, oh my God. And you'll see one of them down below. That's John Lemons with the dog. And the other one is a very prominent environmental law professor, Donald Brown. And they wrote this article, I think in 2011, and they had given up on governance. And they said that there's no way the governments are going to change anything that's going to address the situation. And so they advocated, and these are very straight people, they advocated that we needed to engage in nonviolent civil disobedience and take the and it's called the Anthropocene, where human beings have changed so much that they've actually modified the climate. Now, how are we addressing this crisis, this situation? One of the ways is through this concept of green capitalism, which is, I like this, this quick capitalism is killing us, quick, add more capitalism. Most of these suggestions that are being made are actually compounding the problem, and the profit makers are using the crisis, the global environmental crisis, as an opportunity to make even more money. And the problem that I had when Jordan and I went to the Earth Summit in Rio is they came up with this concept of sustainable development goals, and that's kind of an oxymoron, sustainable development, but it's based on growth, and it basically perpetuates the same idea with an ecological veneer. Another approach that's been made is what's called the public trust doctrine, which is trying to argue that the commons belongs to everybody, and therefore you can't damage it. Wild Earth Guardians brought this lawsuit in Boulder, and it's basically been unsuccessful, but it comes out, again, it's an anthropocentric law because it's saying it came out of originally out of protecting some of the water resources. The first one is out of Chicago, but it's protection of the water resources for future generations. And so it fit in well with the Wild Earth Guardians and their concept of say we're children, their future of the earth and the responsibility to take care of that. And those basically have been unsuccessful. Another way has been going to the, basically seeing water, for example, as human rights, so taking the human rights approach. This is one from Italy. Here's another one, this human rights lawsuit that was filed by the polar peoples at the Arctic area with the Inter-American Commission on Human Rights. It was tossed out basically because of its size. The Uruguayan people have a constitutional right to water. And then there are water is life decision, for example. There's been several of them in Africa. This one's out of Johannesburg. And then in India, there's been a series of decisions. There's about 10 or 11 of them, and I have them if you need them. Some of them are actually in the web materials, where they talk about they have in their constitution the human right to life, and they've expanded that right to life to include, for example, the things that benefit humans, so like tigers. So here they extended the preservation of wildlife. So this would be like our Endangered Species Act or something like that. They've expanded that. But it's created, those have been fairly unsuccessful. They really haven't addressed the root problems. So now we have a perfect storm between climate change, exhaustion of our natural capital, the loss of democratic rights, and the collapse of capitalism. Professor McGonigal from Victoria University in British Columbia has written about this. It talks about a slow burn. A lot of this is talking about, well, if we lose capital, if we exhaust our capital, then capitalism can't survive. So nature will take care of this. As much as us as anti-capitalists would like to get rid of capitalist nature, I think nature's more likely to do it for us. And several people have written about this. It's called the Great Turning, where we have to start talking about system change. And you'll see this demand, and normally when people talk about system change, they're talking about going away from capitalism. I want to talk about that in a minute, but I'll move on. But it's a change in ethics, legal ethics. And this is why it's important in terms of our role as lawyers and creators of law that we discuss this. And we have to develop what we call a post-capitalist future, the end of capitalism. And people are starting to talk about this and think about this. How to develop, what are the laws of a sustainable culture? One measure that's been proposed to substitute for gross national product is gross national happiness. And Bhutan has been developing this argument, but that would measure people's happiness rather than people's wealth. And so it starts to get away from this concept, from this Lockean concept of the importance of property, and that you value yourself according to how much you've been able to obey the will of God and accumulate property and exploit the earth. Ecofeminism has approached this by attacking this concept of domination. And they view that the domination, obviously in the Bible it said that men would rule over women. But it's everywhere. Men dominate nature, men dominate animals, and men dominate women, men dominate Native people. One of the current discussions within Indian law is this concept developed by Steve Newcomb to change the dialogue, the discussion. Instead of the right of discovery, it should be called the right of Christian domination. So this whole concept of biblical domination now is being attacked. It's become a lot of the focus of ecofeminism and relating the victimization of women with the victimization of animals and nature and so forth. And it's an important part of that discussion because it focuses on domination. But I don't think it's a complete picture. There's a little graphic there comparing deep ecology, which does not dwell on the domination, but on the relationship, as well as with ecofeminism, which is focused on domination. Another proposal, and it's a popular one right now, and I'd say it's probably the most popular within left circles, is eco-socialism. I've been involved in left politics and Marxist politics and socialist and so forth for over 4 decades. And I think I'm familiar with Marxism as well as the writings of anarchists and others. And seeing oftentimes that Marxist ideology can be opportunistic. And so what I saw was that with the bankruptcy of capitalism, which is based on largely on the loss of material, the loss of capital, the destruction of capital. Capital is also necessary for Marxism too. It's because you have to have production, and the means of production, and how the product is distributed and benefits from it and so forth. All discussions within Marxism. So they're both economic ideologies that are based on materialism, material wealth. One is shared by private individuals. The other one is shared by the people in common. And but it's still based on that. But anyway, there was, and you may recall that within the Soviet bloc, at the time that it fell, the Soviet countries, the communist countries, in China as well, were as polluted, in many cases more polluted than the capitalist countries were. So socialism, at least back then, for the first 50 years, was no solution for the harms of the earth. In fact, it was doing as much damage as capitalism. And part of that could be understood because they were trying to keep up with the growth of capitalism around the world, and was trying to grow to provide the people the benefits of socialism. But anyway, I see a lot of this eco-socialism. It's not really eco-socialism. It should be called environmental socialism. And if you read the discussions between what would be eco-economics and environmental economics, you'll see that environmental economics relates to the humans and nature, the economics between humans and nature, but it's still anthropocentric. It's focusing on the role of humans in the relationship with the natural world. If you look at eco-economics, you're focusing on nature, and you're looking at nature's relationship with humans, and it's focusing on nature as the primary determinant of that world. So I think eco-socialism is a misnomer. It should be environmental socialism. It's still anthropocentric. Eco-socialists such as Ian Angus and some others refuse to discuss issues of overpopulation. They do discuss consumption, but I think we need to, I think because it is anthropocentric, it won't get into that issue of overpopulation. But I think it's something that has to be discussed. And you'll see this in terms of what socialism is supposed to, which one of these are socialism, which ones of these are Western property. You can't tell. I don't think you can tell the difference. And so the Western way is anthropocentric, which in Western way, I mean both socialism and capitalism. And nature has its value on its relationship to human. All right. And so here you'll see it's known as the triple bottom line: environmental economics. You'll see there people, profit, and planet, how they interact. You get that area of sustainability. John Ellington called it cannibals with forks. There he's talking about when you have this triple bottom line, it creates a situation where you have the wealthy, the people in power, with their forks trying to carve up the planet for their profit, right? And at the Earth Summit, the United Nations call it the 3 pillars. They haven't really changed anything, but they've tried to create an ecological veneer on it. And they say, oh, and they make a big deal out of it as being the 3 pillars for sustainable growth. But all they're doing is perpetuating the triple bottom line. So we have to go from this idea where human beings are the center of the discussion and the ultimate dominant force to where human beings are only part of nature. And so this is more what it needs to look like. Although I would make a much bigger green part, and the other parts would be much smaller, because human beings are actually should be a very small part of the earth. So we got to go from the anthropocentric to ecocentric. It's kind of what we went from Ptolemy to Copernicus, when we went from Earth as being the center to the sun being the center. We're actually at small blue planets surrounding the earth, so we're the human beings of the small people in nature. And so this is a quote from Otto Leopold, who was one of the first ecological thinkers, real ecological thinkers of the 20th century. And he talks about we have to view land as a community, not as something we exploit. And he developed something called the land ethic. There's a essay in his book called Thinking Like a Mountain. That's part of your the webinar materials if you want to read it. It's excellent. But it talks about how a mountain thinks and the interaction between a mountain and a mountain lion, for example, or a wolf, and how a mountain can actually be afraid of a wolf, and how that happens. So we have right now. I think we're in this journey, and this is what I'm talking about from here on. It's the future of environmental and property law, and where we need the direction we need to be going on. And so we have to talk. We have to get. We need to get into the age of regeneration. We're still in the age of separation. And one of the leading thinkers on this is Gus Speth, who was a law professor at both at Yale Law School and at the Vermont Law School. He's one of the top environmental thinkers, lawyers in the world. He was one of the founders of the NRDC. But he talks about not only do we have to get beyond, not only is this a change in how we approach the world from an economic system, economic structure, in terms of our laws and everything. But note this, he talks about we need a cultural and spiritual transformation. And this is key to my thinking as well. And Gus Speth has written about this, but he talks about we really need to change as a race, as a human race, in terms of the way we rate. It's a cult. Think about this. Not only a cultural, which means maybe getting ecological, but also spiritual transformation. What is our spiritual transformation? And so Russell Means addressed this years ago at in 1980 at Black Hills Survival Gathering, and I was with an attorney with the Black Hills Alliance at the time. We put on the survival gathering, and then his address was put in a book by Ward Churchill on Marxism and Native Americans. But he talks about, you'll see that for the world to live, this is the title of his presentation, Europe Must Die. And what he's talking about is for the world to live, the Western way of looking at nature must die. And he's critical of both Marxism and capitalism because they have a material view of the world. And we need to, instead of having a material view of the world, we need to have a relationship view of the world. And a different way, Gus Speth talks about materialism as being toxic to happiness. And we're losing our connection to the world. Theodore Roosevelt wrote a book called Eco-Psychology many years ago on talking about this psychological change that's required. And then materialism has been rejected within a Native worldview. And this is why many of us are turning to Native people to give us direction. It's not that we become Native, but that we look at them as being offering some paradigms that we can adopt to change the world. And foreign lines and land, all of these are basically the same. The land is sacred. So it's viewing the land sacred, not human beings as sacred, although we are part of nature, but nature itself. And therefore, we stand somewhere between the mountain and the ant in creation. And that animals need somebody to speak for them. So this concept of our relationship creates an opportunity for a new sense of governance. And that's the discussion that's been going on right now that I and others I'm excited about and that we're involved in. And it was meant to take place at the Earth Summit, but it really didn't happen there. There were hundreds of thousands of people, millions that were getting into the streets demanding. And the Earth Summit had a sister summit called the People Summit, actually, where we did get into this discussion. And that was put on by Brazil as well. And it's a discussion between the anthropocentric and the ecocentric. And this is the discussion and where we have to go is towards the right if we want to survive. And from the anthropocentric to the ecocentric. So how do we, as lawyers and legal people, what's involved in this? And from an economic standpoint, and mostly we're talking about economic laws and so forth, our approach, we have to go for, it's the end of growth. When we've exhausted the earth resources, we can't grow. Capitalism will fall. So we're talking about a post-capitalist world, and we need to get into something that's truly sustainable. In Europe and other parts of the world, there's something called the degrowth movement that's been very valuable. So it's talking about degrowing our consumerism and getting into a steady state, called a steady state economy. And so that's ultimately where we have to go. If you have limited resources, and this goes back to the limits to growth by Meadows, if you have limited resources, then ultimately you have to approach a steady state economy. We've been living off money in the bank. We've been living off our inheritance, which is the Earth's resources, and we're close to exhausting the bank. So what do you do when you run out of money in the bank? You have to figure out some way of living on what you have. And so that's where the discussion is taking place. So Gus Speth, for example, is something called the New System Project, which you can go online and see. And they're actually engaging in discussions about what does a post-capitalist governance and economy look like. There's another one called the Center for the Advancement of the Steady State Economy and so forth that are having this discussion. Within the environmental community, you have the Earth Law and Earth Jurisprudence efforts, and you'll see these different groups that are involved here. And it shows a difference between Earth jurisprudence and the Western system. We're looking at the Earth community instead of the human community, and so forth. So you have an ecosystem approach and a land ethic. And so an early proponent of that approach was Arness and his concept of deep ecology, which is a rejection of the man in environment image in favor of a total field image. And so it really diminishes the power of humans, and it's for the survival of humans themselves. And now we're also looking at a native worldview. This case, this dissent from Brennan in the Ling case, I thought put it very well. But it talked about, and this was a debate over the religious rights to the religious interests in a native community to a mountain, where they wanted to build a road to a forest, and it was going to interfere with that. And Brennan talks about that native people is a different culture. They're a different relationship with the earth. And they reject concepts of private property, and they are part of the earth. So this leads us to the discussion of living in harmony with the earth. What does that look like? The UN has harmony with nature resolutions from 2009 to 2020 that they've been doing annually. There was a Mother Earth resolution in 2009. They had the World People's Conference on Climate Change in Bolivia, which was pretty cool. And they ended up with this Declaration of the Rights of Mother Earth that Evo Morales presented to the UN in 2010. And they actually have a study on the rights to respect Mother Earth from the Permanent Forum on Indigenous Issues. And so that's been a big push. The other part of that, sister to that, is the rights of nature, and the rights of nature movement, which is done primarily by the Global Alliance for the Rights of Nature, GARN, and the what's known as the CELDF, the Community Environmental Legal Rights, right? And so you'll see that it comes out of this concept from Sierra Club Reid Morton, whether they picked up on a paper by Christopher Stone on whether trees have standing, and William Douglas wrote about it in his dissent in Sierra Club Reid Morton. It talks about the right of trees to have standing. And this is why there's been some real progress. The Community Environmental Legal Defense Fund has led part of this. Two lost battles are the Lake Erie Bill of Rights and the Colorado River, which were within the last few years. But these are ones that have won. Ecuador, you have rights of nature in their constitution. In Bolivia, you have rights of nature. Philippines, it's a writ of Philippine which gives people the right to represent nature in court. And then you have an agreement on the Wangwani River in New Zealand, where it's actually done by treaty with the Queen of England, followed up by legislation with the New Zealand preserving this river. And they extended it to other rivers and to the Speke in New Zealand as legal persons. And these are all success stories here. All of these are places around the world where these various parts of our natural existence have been declared, non-human parts, have been declared to be legal persons to have standing in court, to be where they can be protected. And these are more, right? So this is growing. This is huge. And you'll find a lot of the decisions and some of the legislation and so forth in the web materials that I have. I wrote one of the early ones, actually. I wasn't thinking of it in those terms in 1988 when I was counsel for Western Solidarity, when we sued Ronald Reagan to stop the deployment of the EMX nuclear weapon system. One of the arguments we had on that was that it would destroy the earth. So we made the argument of the right to the world to exist, and to the right of Mother Earth. It didn't get very far, but we actually had that in as a claim. It was part of my, what I call kitchen sink litigation. But this litigation now is being extended to other sacred peaks by Native people. You saw the Mount Taylor, San Francisco Peaks, Mount Tenabo, the Barracks Gold Caves, Mount Graham, which is an interesting one because that observatory there is owned by the Catholic Church. It's trying to build their observatory on top of a sacred mountain for Native people. And then in NAFTA, they had the Glamis Gold Caves, again building a mine on top of a sacred mountain near San Diego. And then Mauna Kea, Hawaii is a recent one that's been going on right now, protecting. In the Black Hills, this is another case of mine on the Hell's Canyon, trying to protect these places. These are sacred places. One of the advantages we have in terms of representing Native people on these issues is that they do have self-determination, and they have, through that, they do have at least some arguable right to own their own worldview, their own laws. And we saw that in the Ling case and in the dissent, but it's even more so in terms of litigation, and it's developing on an international level, and it arises under the free, prior, informed consent. And so it's being raised in the Crow Butte litigation, where we were able to obtain a decision that NEPA has to consider the spiritual and cultural interests of the Native people in the area for the first time. Groundbreaking decision there. And the argument was being made there, the water is sacred and it was going to contaminate the downriver people in the Oglala Sioux Reservation. And we saw, and that was followed up in the Dakota Access fight. And you'll see how it was going to pollute all those Native communities along the Native nations along the Missouri River. And that has seen some recent victories, setbacks and victories and so forth. But this is a seminal struggle because it really pulled everyone together. It pulled the internet, and it started raising things, raising the arguments at the global level with the International Indian Treaty Council and the Special Rapporteur on the Indigenous peoples and so forth coming to that. And then right now we have the Keystone XL pipeline, which is also going to affect Native people as well as rural people on those issues. So we have, these are all raising the issues as to our non-human world and how we argue in favor to support that. And Native people have made this argument. Here's a quote from Crazy Hordes that where we see the whole universe within us, and then he and us will become one. And I see that in Buddhism too. I have studied Buddhism, but they have this mudra here, as Buddha touching the earth, and it's a concept of Buddhist. The story behind this is that Buddha was being attacked when he was reaching enlightenment by a devil, and the devil challenged him and asked him who gave him the right to believe or speak, and Buddha then touches the earth, and the earth spoke to Buddha. And so it's there. But anyway, so we need to go beyond Western legal concepts and look towards harmony and synergism. And I do have a little bit of issue with the natural rights movement, right? With the rights of nature movement. For the reason that I don't think the issue is rights. The issue, rights is really a Western term. And with the Native communities I work with and the ceremony I participate in and so forth, we really talk about relations. The concept of all our relationships, they're all one. So we should be talking about relationships with that tree or relationships with that mountain. Not the rights of the mountain or the rights of us, but our relationship and how do we live in harmony. So the discussion should be around harmony and relationships. There's a book written by Professor Austin from the University of Arizona State University, Indian Law Program there. He was the Chief Justice of the Tene Supreme Court, and he wrote a book on Navajo law, which is all based around their legal concepts of relations and the relationship between the community, and where the goal isn't retribution like we have in the Bible, but in developing balance or harmony within the community. And so there is, where we are, I think we need to be careful about what we think about our place. We're just a speck in time. We're just a speck on the earth. And that's actually in where we are in the universe. And we're all made of stardust. So thank you. I don't know how much time we have left. I hope I didn't eat up all the time. I'd be happy to answer any questions or hear any comments. Thank you. Gordon?
Yeah, thanks, Andy. Let me close the door here. That was a lot. So this recording will be available afterwards, so people can go back and watch parts of it at their own pace. Right off the bat, I think we have 2 questions from NLG folks I recognize and 2 other questions. I'll read, I guess, all 4 of them and see if you want to take each one on your own terms. So one question was if you could explain the Great Acceleration or Great Accelerationism. Another one was talking about Arunness as anti-class posture. What does that mean? Is that something you mentioned in your presentation? The question from Robin Martinez was talking, that's in the Q&A. It says, if private property law's foundations are in Christianity, does that create an establishment clause problem? And there was a 4th question by David Mandel asking, Andy, have you come across the donut economics attempt at finding sustainability? What do you think of it?
Let's see if I can recall those. What was the first one, Jordan?
First one was asking about, you mentioned in your slides, the Great Accelerationism.
Oh, the Great Acceleration. The thing about the Great Acceleration, we're really talking about consumption, which is related to human beings. So it's every organism on the earth consumes, right? So bacteria consumes, everything consumes. But no one organism on earth has reached the point where the consumption is to such an extent that it actually changes the earth itself globally. And so human beings are the first organism that has actually reached the point where we are globally have a global change of the earth, and that's why it's called the Anthropocene. And so that's defined by this Great Acceleration. So what they do is they look at the rise in population, the rise in consumption of all these different items, particularly the rise of consumption of energy and water, food and so forth, the basics. And they see it as really going off the chart and actually occurring within a period of about 100 years. There's a little bit of debate when the Anthropocene started. Some say it started with the Industrial Revolution in the 1800s. Others say it started later after the Second World War. But regardless, it's certainly been within the last 100 years or so that it's had this acceleration, and it's just really shot up. They call it hockey sticks because that's what it looks like. But it's going off the charts. I mean, it's amazing that we would have CO2 levels and population. Our population growth, for example, within the last 100 years, I think it took us something like 10,000 years to get to the first million or whatever. And then in 200 years, we've gotten another 9 or 10, 8 million. And we're expected to have 10 or 11 million by the time the century's out. And they are expecting it to essentially peak. The rate of population growth is starting to slow some, but it's not going to, that's the issue about population. It's not going to slow fast enough to compensate for the damage that we've already done. And that's where this tipping point is. And we're going to go over the cliff. There's actually no question. So the issue is what are we going to do about it? How are we going to deal with it? And so a lot of the thinkers are talking about, well, let's develop some concepts. If you had a new form of governance that was non-capitalist, post-capitalism, what does that look like? And a lot of people talk about socialism, right? Well, what if socialism doesn't really fully address the root problems, which is consumption, right? And so then you have to start talking about balance. How do animals control overpopulation? What are the dynamics, the physical, the natural dynamics of consumption? And so we have to start talking about that. And that's the discussion that others are having. So that acceleration is really talking about us accelerating. It's like going downhill and not being able to stop. I remember once I was coming down a mountain outside Mount Lemmon outside of Tucson, Arizona, and I lost my brakes about halfway down. And so you're accelerating. Mount Lemmon, by the way, is famous because you go from the desert climate up to an alpine climate at the top in a matter of about 20 minutes. But I came down accelerating. Well, that's what we are. We're accelerating our gravity, the gravity of climate change. It's and the gravity of human population, human growth, human consumption. The thing is that on human population, if our goal, and this is the goal of the UN has a goal that we elevate everyone out of poverty. And when we elevate everyone out of poverty, our population growth will slow down. because they find that the wealthier nations have fewer people, have fewer children. But that begs the point, because if you elevate everyone out of poverty, the earth can't sustain that. The earth can only sustain so many human beings. The other problem I have is that to elevate people out of poverty, you create those huge farms and the destruction of the earth by humans, the mega farms, the destruction of these, what are you going to do with a community that's 1 billion people? That it's not healthy. And so I think we need to be thinking in ecological terms. We're only part of the ecology. Well, how much of that ecology do we really get to share in? So anyway, that's a great acceleration. That we're at a point where we can't stop. Everything we do, we can slow it down a little bit. But what we're really talking about, what environmental scientists are talking about, is mitigation, not stopping. So we're already going off. We're going off over the hill. But Jordan, what's the second question there?
Someone mentioned arunness.
Arunness, I'm not sure. I didn't understand that.
Posture. Maybe they heard the first part wrong.
Anti-what? Anti-what?
Anti-class posture.
Anti-class posture.
Do you
Are
remember
you talking about the Marxism, the metabolic rift? Or I'm not sure.
Maybe they can clarify. I missed that as well. The other question was from David Mandel on the donut economics attempt at finding sustainability. If you've heard of that, and if you have any thoughts on it.
I'm sorry, on the what kind of economics?
Donut economics.
Oh, the donut economics. Yeah, I've heard about that. And I think some of that comes within the corporate social responsibility discussion. And I didn't own up on that for this discussion, so I don't really have that. I think the point of my presentation isn't so much to discuss the ins and outs of Western economic theory, but to talk about that we really need a new paradigm. That all theory, and it comes out of the Greeks and the Romans, out of Aristotle and Plato and those guys. You can trace the whole pattern, and it comes from this division of us between our natural world. And that as long as we're divided from our natural world, and that's what some of those quotes I was showing you, as long as, and this is one thing that Aldo Leopold talked about, as long as we're divided from our natural world, we're fated to failure. And I would take that even farther. As long as we're divorced from our spiritual relationship with the world, and I don't mean that in a religious sense, but I mean that in a real sense. In other words, it's not a cold relationship with nature, so that we have to figure out how to push green energy to a point where we can all survive because we all have solar power. That's not the discussion. The discussion is that we actually have to have an ecological conversation. And in order to have an ecological conversation, we have to discuss how do we live in harmony with our natural world. And if we're going to have a large community of 1 million people or 100,000 people or 10,000 people or 1 billion people, how are we going to organize our relationship with the natural world so that we live in harmony? So it becomes a steady state relationship that we don't end up destroying ourselves and everything around us. So I'm sorry, I can't address directly that discussion on the donut economy.
The person clarified you had showed a author, Arne Ness was the name. Does that ring a bell?
Arne Ness on deep ecology. And he was one of the early ones, one of the first, along with Aldo Leopold on the land ethic, that talked about developing a new relationship with the earth. Theodore Roszak talks about that in ecopsychology. But the difference between Arne Ness and Aldo Leopold is that Arne Ness almost takes like an earth first approach, where human beings are essentially a cancer on the earth. And part of developing that deep ecology, that deep relationship with nature, you have to develop a strong sense of humility, that humans have no priority. They have no superior value to any other part of nature, and certainly not to a mountain or a stream or even to an ant. And that's where I'm saying that our profession, in terms of proper thinking on this, developing a correct ethic, a correct law. Law is just simply a written ethic. Developing a correct law approach to this has to deal with our relationships with nature as much as our rights and nature's rights. Anything else?
Yes, we had a question from Robin Martinez on if private property law's foundations are in Christianity, does that create an establishment clause problem?
Yeah, good luck with that one. part of the problem is you know, we become indoctrinated with this stuff so long. There are interesting discussions within the anthropological and the sociological communities. The experts on that, if you read that stuff, for Native Americans, for example, we saw that in 1984. It's called doublethink and things like that, where you end up with this, with the people in control, the people in power create a language, a way of thinking that indoctrinates everybody to that. And so we've become so indoctrinated with these concepts of property law. For Indian lawyers, we see that when we go to law school, we become indoctrinated with the concepts of federal Indian law, which is actually colonial law. And so they're teaching us the rules of colonial law to use against our own clients, and we become agents of colonialism, unknowing. But we do that innocently, and we think that we're doing good. You'll see that some in that recent decision issued by Gorsuch on the Creek Indians in Oklahoma, Creek Nation in Oklahoma. So so we become indoctrinated. Well, we become indoctrinated in even in environmental law. So environmental law, we think more in terms of regulation, not in terms of actual stopping things. So the way that we stop things is by over-regulating. Find some regulation that they don't meet. We're unable to make the argument that no, that's actually wrong. It's wrong to take that mountain or take that river, you know, or take that species. It's simply wrong. And that's all we have to argue. We don't have to argue regulation. We don't have to argue its value to human beings. You know, it's simply wrong. And because it has, so we've been indoctrinated so that we don't even think in those terms. So when the DAPA lawsuit was filed, Earth Justice filed a NEPA claim and a Historic Preservation Act claim, which are essentially environmental claims. And they didn't even file a treaty claim or any kind of claim for pre-prior informed consent. And they didn't really file any claim that strongly pushed the spiritual value of that land and the ancestral relationship and so forth. So they were trained not to think in terms, or they didn't file the claim arguing the value of the river. And so, and even though those claims probably would, well, almost certainly would not succeed, I do think we have an obligation as ethical people, as environmentalists, and as Native lawyers and so forth, that we have an obligation to make those arguments and raise them in court. So I think we have to go outside the box and start making that argument. So in answer to Robin's question, because property law is Christian doctrine, I do think, you know, maybe someone should start raising that. I mean, there's no dispute. There's no dispute that Native people are colonized. There's no dispute, but people don't want to talk about it. Every federal Indian law recognizes that Native people are colonized, but nobody wants to talk about the law of colonization, right? Federal Indian law there's no dispute. Native people are colonized. Well, what does that mean? Really, no Indian lawyer wants to talk about that, right? In environmental law, right? Everyone agrees that nature should have intrinsic value, that a river should have intrinsic value, right? That's the right to nature. But every time it's raised in court by the Center for, by the Community Legal Environmental Defense Fund, right? And other organizations, they get tossed out, right? So most environment, and they're the exception, most 99% of the environmental lawyers won't raise that argument. And in fact, when it was raised for the Colorado River, the lawyer there got threatened with sanctions for raising frivolous arguments, and he pulled out of the case and dropped the case, right? So we got to change our thinking so that we realize, and maybe that would be the way to approach it, was Robin is saying, that Western property law is Christian doctrine, and that we need to start looking at different paradigms. It's not only Christian doctrine, it's a failed Christian doctrine that has led to the destruction of our own environment and the earth, and that we need to start thinking in different terms and having a different discussion.
We just got a new question from Paul Bartlett. He heard at an ecological economics conference that there's a network forming to develop ecological law from scratch for long term. Do you know if that's happening and who they are?
Yeah, it's happening some. There actually is you can get an SJD, and I think an LLM in Earth Jurisprudence at Barry University in Miami.
Orlando.
In Orlando, you're right. And they're having the discussion, what is Earth Jurisprudence? Now, is based on the writings of Barry, which is kind of like Aldo Leopold, although he came from the Catholic background. And you see some of that in the ecumenical order or whatever of the current Pope, those concepts of starting to develop an earth jurisprudence, where we start having a different discussion. And the way to start that is probably from the ground up, what we're seeing in the local communities, but that's being shot down by the preemption doctrine and the federal and state and federal supremacy. So in order to really change it, then you're going to have either a change in governance, or you're going to have it coming from the top down, which means the U.S. Congress and the state legislatures. And you're starting to see that in Pennsylvania, for example, they have an environmental constitutional amendment that's been used in order to promote some of this. That's been successful, and it's been sustained in court. And so that can be extended. In Mexico, they have a constitutional amendment for one of its provinces that's been in place. In other places around the world, they've had laws like in Uruguay, Ecuador, and in Bolivia, and places where they've had law of nature and rights of nature and so forth, legislation. And so if we can reach a point where that can be put in and accepted, and I think the United States may be one of the last places to do that, it's going to have to reach a point where they're going to get overwhelmed. And you saw those photos I have of all those rivers and mountains, and there was a tiger in there, and a leopard, and even bees. Bees have been given standing in court. In a mountain, several mountains have been standing in court. Once that has it become a common occurrence around the world, then I think we're in a much better space to have it happen. Probably in a place like California, or in a progressive state, and then maybe get it extended a little bit. Hopefully the states' rights people would be in favor of allowing that to happen. But anyway, I do think that we're in line for a change. I don't see where we have any choice, frankly. It's going to happen over the next 40, 50 years through the collapse of capitalism and this natural disaster that's coming on, that's creeping on us very rapidly. I mean, the rate of climate change is unheard of in the evolution of nature and the environment of the world. I mean, the rate that the CO2 levels have climbed and the rate of climate change, the rate of the warming in the earth, is almost unheard of. And so we may think it's happening really, really slow, but in terms of the geology of the earth and so forth, and the evolution of the earth, is happening extremely fast. And making these predictions, think about it. Half the species of the earth will disappear by the year 2100. And that's a consensus. It's not some wild scientist off in but think about that. We've already lost 40% of the pollinators, the bees on the earth. The oceans are collapsing. The cod and the cod supplies in the northern Atlantic collapsed a few years ago, and had a major disaster. The Gulf streams may reverse direction as the oceans warm. What's that going to do? It's going to change the climate of the earth. That's going to happen in maybe not in my lifetime, because I'm too old, but certainly in the lifetime of my children. And that's why the kids are so up in arms about it. They understand that. The ultimate victims understand that. That's why the kids are in the street more than us. And so I think we need to listen to them. I think as legal people, we need to support them, and we need to start giving them the tools that they need to enter into the next generations of change here, where we do paradigm shifts. And we need to look to our Native brothers and sisters, our Native relatives, to help guide us into a more ecologically sound approach. But I find this exciting and terrifying and exciting at the same time.
I have one more question. It's my own question, which is, I represent the Environmental Human Rights Committee of the Guild. Natalie represents the Indigenous Peoples' Rights Committee, and we always put the apostrophe after peoples and Indigenous people's rights. Do you want to touch on that and explain? I don't know if you touched a little bit on that sort of concept in the presentation. And another small question is, I don't know if you touched a little bit on geoengineering and plans to do that at all in your presentation, if you had any comments on that.
Yeah, I'll answer the first. Go ahead.
Andy, You just got one more question that I think is relevant to that too, from Victoria King. How exactly do First Nations, Native Americans apply and honor the treaties with colonial governments when it comes to land claims? Are the treaties a strong tool the Native peoples have? And I would just add to Jordan's question as well, you know, as immediate past chair of the Indigenous Peoples' Rights Committee and former chair also of the Environmental Human Rights Committee, if you can expand a little bit on, you know, the differences between, I think you have throughout the presentation, but environmental human rights and how you see that versus just strict environmental justice.
Right. Well, environmental human rights, again, are anthropocentric. They're human rights, right? So if you're talking about the rights of a tiger in India, you're talking about the value of that tiger to a human being, right? You're not talking about the intrinsic value of the tiger, the right of the tiger itself. And so human rights are a very limited way of looking at it. It's a little broader picture because it gets us away from the individual rights concept. We have individual rights, we have human rights, and then we have natural rights, we have earth rights, and then we have what I like to consider relationships, right? And so individual rights are like capitalism, private property, that kind of thing. Human rights are more of a collective concept, right? So socialism fits better within the concept of human rights, particularly with people's rights, the people with the S. What the S is talking about is a collective right. If you put apostrophe before the S, people, apostrophe S rights, you're talking about individual rights. So the rights of an individual native person. If you put the apostrophe after the S, you're talking about the rights of peoples. So for example, in Cochabamba, we had the World Peoples Conference with an S. That's talking about collective peoples. In the UN Charter, they talk about we the peoples. They have an S after it. They don't say we the people of the world. We the peoples of the world. So it's a grouping of peoples. And what peoples are, they're peoples with a common, usually with a common history, a common location, common environment, common territory, common culture. You know, and that's what creates, it's that collectivity, that collective interest, that interpersonal relationship that creates that concept of peoples. It's think of tribal. And then a nation would be a level up that, you know, a nation could be a tribe or it could be a group of tribes, a confederation. The Sokaogon, the Great Sioux Nation, for example, is actually a confederation. 7 council forms, nations together. The Iroquois Confederacy, for example, is a confederation. Bolivia is a confederation. Called the plurinational state of Bolivia. So it's a confederation of native nations with the state of Bolivia that creates one nation state. And so they figure out how they relate to each other. So these concepts, and this to address that first question too, and then it'll hopefully tie into the treaties. This concept of peoples is a concept of collective interest or collective approach. And when you enter into a treaty, it's a treaty of peoples. You don't make a treaty with an individual, you make treaties with peoples. It's a nation to nation, so treaties can only be made between sovereign powers, right? We did not used to have nations and nation states. We did have sovereign powers, kingdoms, for example, but they were not considered nation or nation states. We had tribes in the Americas, for example, that were not, they didn't have the Western concept of nations and nation states. They did have a general concept of territory, hunting grounds, and so forth, ancestral grounds, but they didn't have this concept of territory. They actually didn't arise until after the First World War. It was about that time in terms of this concept of nation states, and the League of Nations, and then the creation of the United Nations. So it's a relatively modern or new invention. And so for Native people, when they start talking about, well, let's use international law and let's use the treaties and things, one thing that needs to be understood, and I tell this to my clients as well, that's still Western law. International human rights law, international treaty law, the Vienna law and treaties, those are all white, Wasatch, Western law, right? That's not Native law. That's white ways of doing things. Now, they offer different opportunities than you have in the domestic colonial law, but they were designed to support the exploitation of peoples in the earth. The whole concept, and you saw that in Battelle on the Law of Nations, the whole concepts of international law and the Law of Nations were designed to support the people in power, the owners, the colonizers. They were written by the Western colonizers. They were the ones that designed international law. But over time, it has evolved. That's one of the nice things about international law. It's fluid. So over time, it's evolved and it's become more responsible towards the victimized people and the people without power. So that now it's starting to accommodate them. And one of the reasons why that's happened is that the victimized people, the people without power, have been calling the people in power to terms on their own commitments, their own ethic, their own moral commitments. You know, so if you sign a treaty, you make a moral commitment. That's in the case that was just decided. If you signed it, the United States signed a treaty with the Creek Nation, it made a moral commitment on that treaty that it should not be allowed to escape, right? And so Native people are doing that now on the international level because they were unsuccessful on the national level. One of the problems with the recent decision today is after saying that, then Justice Gorsuch then goes on and say, yeah, but Congress can take it any time. Congress, because it has plenary authority and Native people are colonized independent nations, Congress has total control over them and they can take their territory anytime they want. They just haven't done it yet. That's why the state doesn't have jurisdiction. But they can take that territory anytime the state can get jurisdiction, no problem. You know, that's the Gorsuch opinion, and that's a root problem with taking that approach. So treaties can be enforced, but they have to be forged on a nation-to-nation level. And now when the U.S. government discusses it with Native peoples, for example, they've stopped talking about nation-to-nation. Now they talk about government-to-government. What do they do? Government, South Dakota, Colorado, California with the United States, with federal government, that's government to government, right? That's treating Indian nations as states, Indian reservations as states. Well, they're not states, they're nations. And so colonialism would prefer a government to government, but it's a nation-to-nation relationship. Where does nation-to-nation belong? It does not belong in a colonial court. It does not belong in the federal court. It does not belong in the state court. It does not belong in the U.S. Supreme Court to determine its own colonial treaty, right? It belongs in an international court or in a tribal court. And so, and that's part of the discussion we've had over the Apple litigation and some others, is how to bring this, how to ethically and morally bring this in a responsible way that affirms and recognizes that Native nations are colonized people, and then a process of decolonization, and you don't accept the colonial rule of your colonizer. You have to resist that, and you can still go in the courts of your colonizer and resist it, but you can't drop that argument. We can't, and this maybe gets back to Robin's argument a little bit. If we're really talking about a paradigm shift in property law and the way that we think about nature and the way we think about property that's ecological, then we have an obligation to go into court and argue from that. So we can argue from that law saying, we really need to take an ecosystems approach, you know, in this, and we really need to consider the intrinsic value of this mountain that's going to be dug up, you know, or this river that's going to be contaminated. We really have to, and that has to be part of the conversation. It doesn't mean then that you don't drop and say, but the dominant authority, which is the federal government or human beings, have said that they're placing these restrictions upon their own actions. And so then you use federal or state environmental laws or whatever to govern the restrictions on the exploiter, the restrictions on the dominant party. Then you can use it in that way, but you only use it in that context. You don't give up your own relationship with the earth and your own responsibility. For Native people, it's the responsibility to care for that river, or to care for that, or to care for the buffalo, or to care for the four-leggeds and so forth.
Andy,
So
I think we have one last question, just as we're wrapping up, from Paul Bartlett. Many Indigenous languages are relational languages with relational ontologies, whereas English and Western languages are object noun-based, which has inherent separation. What does this mean for writing eco-law? I
think it's crucial. And one of the things when I counsel as a lawyer, and I'm not trying to tell him what to do, but as somebody who has read something and has some knowledge about colonialism and how it works, it's a colonization of the mind. One of the ways they colonize the mind is through colonizing the language. Doctrine of discovery instead of the doctrine of domination, right? The Defense Department instead of the Department of War, things like that. But anyway, so in terms of native languages, not only incorporate their whole culture within a name, their history is there. The culture, the language, the description of that provides that, it brings it alive. That's why some of the words in Hawaiian or in Maori are so long. Is each river has an, it's not a river. It is a being with a name, with a separate name of its own, And so native language has that. English has dropped that. English is cold and it's hard and it's dead. And it's like property law. It should be Christian property law. We dropped the Christian, made it dead. It's no longer alive with God. It's no longer alive with Christian virtues. All right, although Pope Paul has tried to revigorate that. But for native languages, yeah. And so one thing I've said, for example, when I filed something with the court recently in Crow Butte, I didn't use the name for White River that runs through the Oglala Sioux Reservation, the Oglala Reservation. I used the Indian name. I used the Lakota name for that. And I talk about the Lakota people. And I talk about the Oglala Lakota, not the Oglala Sioux tribe, for example. And for the DAPL, when I prepared some of the arguments in that, including the arguments that were submitted to the international bodies, and the argument that and worked on some of the stuff that was submitted on the divestiture and some things like that. We use the names, the native names of those rivers, Cannonball River, right, and the Missouri River and so forth. I don't know those names offhand, but on those occasions. And the other thing I've been talking with my friends about is that if we found something, next time we found something, let's translate it into Dakota, and send that to the federal government, and let the U.S. lawyers have to translate that back into English, and that the more that we need to change all the names in native country back to their native names and force the visitors to those territories, to those nations, speak their language. It's about time that native people are not forced to speak the colonizer language, because every time we speak in the colonizer's language, it's colonizing the mind. And so that's one of the first things we have, and that's why the preservation of native languages is so important. It's crucial to the survival of native people, not only the survival of native people, but the survival of the earth, because it's that language that ties them to the earth. It's that language that has their spirit, that is alive. It's that language that has that ecological value, that references that ecological relationship. That when you give that native name of the river, it gives it that special identity that says that I am a being that exists and has a right, or to the mountain, or to the animal. That ties you into that animal directly, or into that river or mountain, and it forces that discussion to discuss that entity as a sacred being. And I think that's something that's an opportunity that we have right now by engaging native people with us in this kind of litigation. I don't know if that answered the question, but that's what I think.
Yes, Andy.
Yeah. I appreciate everyone that's on. I noticed it started at 1:48. Now we got 31 people left on. And I appreciate everyone that stayed with me. But I think that I just want to say that I hope this discussion will continue and that you'll think about it. I do think that we are in a very serious time. It's a perfect storm. And I think that in our lifetimes or our children's lifetimes that we're going to have to think in different ways. And hopefully we can have more of these kinds of conversations and look for our friends who are ahead of us in this way of thinking, our native brothers and sisters, and the animals of the world, and the mountains and the stream. Read Aldo Leopold's Thinking Like a Mountain, and you know what I'm talking about. That we need to go to them for help. Otherwise, we're looking at our own life. Thank you.
Thank you, Andy. I think I speak for Natalie that it's been an honor to have you as a friend, a colleague, and a mentor over these past 10 or so years. So we really appreciate you.